Hey, if you're an international student in Australia, please stop what you're doing and listen to this. To give you some context, I've been a lawyer for more than 3 decades, and for the last 25 years and more, I've worked exclusively in the immigration space. And over that time, I've seen laws change and problems come and go. And in these videos, I want to share the real world cases that I encounter to help you as a student, as a migration professional, or an applicant in the future, or a sponsor of that applicant. If you find this information useful, please do encourage me by hitting that follow button. Now let's move on to today's topic and look at why this particular case is so important to share with you. Let's look at the dates, because the timeline here is truly painful. This student lodged her 485 visa application on the 17th of May 2023. Just a few weeks later, in July 2023, she received an official refusal from the department. She sat in professional and personal limbo for 31 long months, never seeing her parents or her family, all the while waiting for a chance to fix a mistake that legally cannot be fixed. In addition to that, the financial cost of this wait has been staggering. Back in July 2023, she appealed to the AAT, as it was then, and paid a filing fee which was $3,152. After waiting nearly 3 years, she finally received a directions hearing email a few days ago, thinking that because she retook her English test and passed shortly after her appeal was lodged, she would finally be safe. I had to be the one to tell her that the law simply doesn't work that way. Moving forward, you have to understand that the tribunal is bound by the same rigid rules as the Department of Home Affairs. Under clause 485.212, the English requirement is a time of application criteria. Unless you hold a passport from an exempt 5 nations, the UK, the USA, Canada, New Zealand, or Ireland, you must satisfy English the moment you hit that submit button. Malaysia is not on that list, and because she didn't meet that requirement on May 17, 2023, no amount of legal argument can save her. Her application was dead on arrival. Let's clear up a common and dangerous myth about providing evidence. There are 2 scenarios that will guarantee a refusal. The first is when you have sat the test, but you don't have the test results yet. Uploading a placeholder or the receipt won't save you. The second, and even worse, is offering a receipt for a test you haven't even sat yet. In both cases, you have failed to meet the law at the time of application. You cannot patch a 485 visa with a late result. The law requires evidence to be valid, and in your hand, the microsecond you pay that fee. Interestingly, many people ask if there is any flexibility here, but the federal court has been very clear. This microsecond rule is grounded in established case law. Milanes and the minister, the court confirmed that they cannot satisfy the English language requirement with the test taken after lodgement, while an older case called Brangwell once suggested some flexibility. The law was specifically amended to close that door. More recent authorities, like the Minister for Immigration against Thapa and Kaur and the Minister, have reinforced that if the results aren't ready when you apply, the tribunal cannot step in to help you. Now remember that the 485 visa has 3 non-negotiable pillars. Number 1, you must have held a student visa within the last 6 months of applying. Number 2, you must not have completed your course more than 6 months ago. And number 3, you must meet the 2-year Australian study requirement. For this student, the bridge back to is almost impossible. To try again, she would likely have to go back to Malaysia, apply for a new student visa from overseas, a massive hurdle given she's been unproductive in the eyes of the department for the last 3 years. And to make matters worse, because she's had a visa refused while on a bridging visa, she's subject to the Section 48 bar, which means she's legally blocked from making most other visa applications whilst she stays here in Australia. That's the operation of the Section 48 problem. In 2026, the department is also much stricter on the genuine student requirement. Proving that she is a bona fide student after a 3-year pause on a bridging visa would be an uphill battle that she is frankly unlikely to win. So what are the takeaways? The first is the Micro Second Audit. For a 485 visa, time of application means Your evidence must be valid and in your hand before you click submit. If you pass your English language test even one day after you lodge, it is legally the same as if you never took it at all. Never, ever lodge on a promise of results. The law only cares about what was true the moment you applied for that 485. Number two, the second takeaway, do not let a bridging visa give you false hope or a false sense of security. This student stayed in Australia for 31 months, terrified to leave because she thought she could fix her position at the tribunal. A bridging visa keeps you lawful, but it cannot cure a fundamental failure of criteria. If your original application was flawed, paying a $3,580 fee is often just paying for a very expensive and a very long delay of the inevitable. Finally, don't let your Australian dream end because of a calendar date. If you are preparing for your graduate visa, or if you are currently stuck in a tribunal appeal and want to know your real standing, book in a consultation with one of my team or a registered migration agent or lawyer. Share this with every international student you know who might benefit from this, and let's stop these preventable heartbreaks before they happen. Thank you for listening. I'm Nilesh Nandan, and this is Rocky, my cavoodle.